Hello friends, welcome to my channel. This is the girl Mercy. If you're a returning subscriber, I appreciate you. If you're new here, please subscribe to this channel, click the like button and share this video. So today I'm going to talk about the law language. This channel I talk about law practice, talk about the life of a lawyer, talk about career path, talk about tips for excellent practice. So as a lawyer, we are known to be learned people. So as a lawyer, you must strive to learn how to use the law language or the law terms appropriately. It distinguishes you and puts you above the crowd. So today, even as a non-lawyer, you can also learn from this video. So the first word to use, I'm going to talk about today is recuse. When the word recuse is used, it means to step aside. Because, okay, my Lord, I pray that my Lord recuse from the matter. Step aside. The another one is subpoena. Subpoena is a document issued by the court summoning someone to appear before it, either to testify or to give evidence. If you have to give evidence, it's called a subpoena ad testificandum. If you have to tender document, is a subpoena dus tecum. Another word is alimony. Alimony is a matrimonial term. It's an order from the courts with respect to a spouse paying another spouse money for maintenance, or it's always used in a divorce proceeding. Another one is de novo. De novo means starting all over again. Sometimes in the suit where maybe a judge has been transferred in the course of handling a matter and another judge comes, depending on the stage of the matter. Most times it's always you start all over again. So de novo is used means starting all over again. Another word is act of God. Act of God is a circumstance or something that happened that is beyond human making. Maybe there was a storm, thunderstorm, or something that happened that caused an effect. So it's an act of God. Nobody really planned it or nobody caused it. It's a natural consequence or a natural occurrence. Another one is lapsed. When the word lapsed is used, it means expired. My Lord, the time has lapsed. Another one is acquittal. Acquittal is the abolition of a criminal charge. Sometimes in court you hear the accused is hereby discharged and acquitted. It means everything is over. But if you just is discharged, discharge is temporary, just for the meantime. He's not yet acquitted. So acquittal is abolition of a criminal charge on someone. So it's different from discharged. Another word is supra. When the word supra is used, it means above. Maybe you're writing a brief and you've started a case in the introduction of the brief or in the beginning, then you have to repeat that same case later. Then you don't need to write down the full citation again. Just state the case and bracket is supra. It means you are giving the citation as above. Another one is the local standing. Local standing is the legal right to sue. The other one is obiter dictu. Obiter dictu means something that was said in passing. Maybe it's always used in a judgment. When a judgment is being given, sometimes the judge says things in person as he is writing the judgment. It's not really the order of the court. So it's called obiter dictu, something that is said in passing. Another one is lis pending. Lis pending is something that is subject to litigation. Another one is amicus curiae. It means a friend of the court. Sometimes a lawyer will appear in court and say, Lord, I appear in court as a friend of the court. That's amicus curiae. So another one is power of attorney. Power of attorney is an instrument of delegation of power. So when the word power of attorney is used, literally means an instrument that delegates power. Another one is let's say is accused. When the word accused is used, it means someone that has been charged with the criminal charge. Another one is defendant. Defendant is the person who is defending a suit. Claimant is the person who instituted a suit. Another one is void. When the word void is used, it means it is of no effect. Just like nullity. Nullity is something that is has no legal basis. It's nullity. There is no legal if I say I want to use this very clear word, something that's just of no value, that's just the literal plain understanding. Something that is of knowledge, is a nullity, is of no legal effect. So something also void is something that is of no legal backing, of no legal effect too. So sometimes so to these two words are used, is of no effect and is void. You know. So as a lawyer, you must know how to use these words interchangeably. Another one too is what I call, I wrote them down, that's why I'm looking at my book so that I wouldn't forget them, is res judicata. You know, res judicata, where a matter has been finalized and it's been instituted again in another form. You know, you can say this matter, my lord, is res judicata. So today we have done few words, and I know that you've learned something. Please look out for the next video where we'll continue on this language of the law, or the lawyer's language. It's very important. You must know how to speak the law terms and speak them appropriately and in the right time and in the right situation. Thank you for watching. I'm grateful.